Good morning, Ms. Hofmeyer. Good morning, everybody.
Good morning, Chair.
We're starting 10 minutes late because of meetings to try and sort out some procedural issues. Are you ready?
We are indeed. Chair, if I may
Yes.
just ask for an opportunity for Ms. Memela's legal representative to introduce herself and place herself on record.
Yes, thank you. Ms. Mbanjwa, come to the podium here. Come there.
Thank you, Chair.
Yes.
My surname is Mbanjwa, spelling it for the Commission M-B-A-N-J-W-A.
Yes.
The initial is L, full names Lindelwa, L-I-N-D-E-L-W-A. I am
Yes.
on record for Ms. Memela.
Thank you very much. Thank you. Ms. Memela, good morning. You are still under oath in terms of the oath that you had taken last week. You're happy to give evidence on the basis that that oath still applies, is that right?
Yes, Chair.
Yes, thank you.
Thank you, Chair. Ms. Memela, where we concluded matters on Friday was we'd begun to look at the agreement between Swissport and SAA, out of which the sale of the GPUs.
Oh, sorry.
Chair, I just want to point out a procedural issue. I noticed that Ms. Hofmeyer has some funds.
Yes.
I just wanted to point out that if she is going to refer Ms. Memela to documentary evidence,
Yes.
may I please also be furnished with those documents, if there is a file provided for me, as it pleases Mr. Chair.
Yes. Ms. Hofmeyer?
Yes, Chair, we do have an extra copy. We'll make them available to Ms. Mbanjwa immediately.
Yes.
I only saw Ms. Mbanjwa here at a few minutes to
Yeah.
10, so that is
Yeah.
why all of these processes haven't been managed to be done yet, but
Yeah.
she's just been handed copies.
Yes. Okay, all right. Thank you. Then you can switch off your mic, Ms. Mbanjwa. Thank you. Yes, okay.
Thank you. We had concluded matters on Friday with the beginning of the role that you played in relation to the sale of the GPUs.
Ms. Hofmeyer, I just wanted to say to Ms. Memela, I'm sure you feel much more comfortable today with your lawyer here.
I do, Chair. I know that it was stated that I'm a lawyer,
Yeah.
but of course, as much as I am a lawyer, I am a human being.
Yeah.
Certain things like touch your emotions and you end up maybe reacting irrationally. So
Yes.
I'm happy that my
Yeah.
lawyer is here.
No, that's fine.
Thanks.
Thank you. Yes. Oh, please come this side if you want to say something, Ms. Memela.
Chair, I just need to be guided as to procedure. Because in a normal court, if a statement is put to the witness, which a legal representative is of the view that is not factually correct, there would be an objection. But I do not want to keep interjecting. So I propose the following. A statement will be put to the witness, which I believe is factually incorrect. But then I will wait my turn. Like for instance now, the statement that has been put to say, the conclusion was about the role Ms. Memela played in the GPUs. There will be an objection to that, but I'm proposing that when I keep quiet, it's not that we accept those statements, but we will just at the end of the proceedings of Ms. Hofmeyer.
Yes, yes. No, you don't object necessarily because what is being put to the witness is not factually correct, because the witness will point that out. That's not true. Of course, there could be something if, for example, there is a factual assumption on which the question is based, where you could point that out. But most of the time, it's matters that really can be clarified during re-examination. So if you don't say anything, I won't assume that you agree.
I am guided properly. Thank
Okay,
you.
all right.
Ms. Memela, if we could pick up your evidence at page 5 of Exhibit DD 25A. It contains your statement.
Well, Ms. Mbandwa, I just want to say, for what it's worth, while you must feel free to protect your client's rights as much as possible and where necessary object, I can assure you that over the past 1.5 years or so since this commission started having hearings and hearing evidence, there have been a lot of lawyers who have represented witnesses and implicated persons. And it's difficult to remember people who have objected a lot. Mm-hmm. I think there is only one that I can remember who objected quite a lot. I think a lot of people find that there is an attempt to be as fair as possible. But that's not to say when you think there is reason to object, you mustn't. But I'm just saying that mostly, I think most lawyers, seem to feel that questions that are being asked are fair and so on.
Well, Chairperson, I do not know about the questions because I watched the meetings.
Yes. Yes.
I can only say we have full confidence.
Yes.
In the Chairperson's impartiality.
Yes.
But sometimes.
Yes. Yeah, no, that's fine. No, when you feel that there is something and you feel it's something serious, feel free to object. Okay. Thank you.
Thank you, Chair. Ms. Memela, I wanted to pick it up at paragraph 15 on page 5, because there you start to talk about the role that JM Aviation played in relation to the sale of the GPUs. And if I can pick it up in the middle of that paragraph 15, you say there in your statement, from SART's side, JM Aviation never mentioned that they would be reselling the GPUs to Swissport. What we understood during this discussion was that they were buying them from SART as the Swissport BEE company to cover the 30% set-aside mandate by SAA to all suppliers. Do you see that?
I see that.
Does that remain consistent with your account of the events?
Okay, remember on this paragraph, I was talking about open water, how they have investigated this whole transaction, Chairperson, in terms of like them coming out or maybe reaching the conclusion that the GPUs were sold below market value. So what I was trying to highlight was the fact that as much as I was not involved in the decision making and all, they did not test the market, nor have they showed anything that showed that it was supposed to be this much. Instead they relied on the agreement or maybe the arrangement between JM and Swissport in terms of like reselling each other the GPUs, which is not to our position or maybe SAT's position. They only know that. So I was coming from that angle. Of course, I don't remember during the discussion, Ms. Hofmeyer, that where JM representative said they were going to resell to Swissport. When we discussed, they were talking about, okay, they have learned that the Swissport and SAA contract has been signed, and they have made a proposal to the acting CEO at that time, and then from that they wanted to negotiate and see a way forward. So whatever that they had agreed upon with Swissport, it did not really include SAT because now it was already out of SAT's hands. Yes.
Thank you, Ms. Memela.
Ms. Hofmeyer, I didn't want to disturb you, but when you indicated what page, I was trying to get a pen.
Apologies, Chair. We are at page 5
okay,
and paragraph 15.
Okay, all right.
Ms. Memela, the part that I was actually interested in your statement is when you said what you understood in the last sentence. You said, what we understood during the discussion, this is the discussion with JM Aviation, was that they were buying the GPUs from SART as the Swissport BEE company, and I place emphasis now on the part that I'm interested in, to cover the 30% set-aside mandate by SAA to all suppliers. Was that
Yes.
your understanding at the time?
At the time, that was the understanding, and remember, I did mention on Friday, Chair, that the 30% set aside, it was something that was put on the table by the then chairperson of SAA, and I think the board, because maybe she was not acting alone, and I have, in my capacity, never ever applied that in terms of, for SAT contracts, so that's why I'm saying maybe in the Swissport contract, which you have seen and you have directed me to on Friday, that maybe they were the reason why maybe the amount from what we, SAT, had sold the GPUs for, it went up when these guys sold it to Swissport because of maybe a certain arrangement with regard to 30%. That was our assumption.
Right. And your evidence on Friday was that you yourself regarded the 30% set aside as unlawful. Is that right?
Yes. That's
So-
why it was not applied at SAT. Remember, I'm talking on behalf of SAT, not SAA.
Indeed. So when you started engaging with JM Aviation with the understanding that they were playing a role because of the 30% set-aside mandate, did you raise with anyone that you shouldn't be dealing with them because the 30% set-aside mandate was unlawful?
Okay, can I understand the question again?
Certainly.
Yeah.
Your evidence on Friday was that your view was that the 30% set-aside mandate of the SAA board was unlawful, correct?
Mm-hmm.
And then you indicated that your understanding at the time of your interactions with JM Aviation was that they were playing the role of the Swissport BEE company pursuant to the 30% mandate. Is that correct?
That's correct.
And then my question was, well, if you regarded the 30% mandate as unlawful, did you at any point in your interactions with JM Aviation about the sale of the SART GPUs raise with anyone that you shouldn't be dealing with them because the 30% mandate was unlawful?
Chair, the role that SAT played, there was absolutely nothing that could maybe nullify the decision that had already been made by SAA board or maybe SAA procurement, because remember the decision had already been made there. So the only role that SAT played was the selling of the disposal of these GPUs as per the board's mandate. Now, just to give clarity in terms of why I said the understanding may have been they relied on the 30% set aside. I told you, Chair, that on Friday, Open Water had never given me or anybody else who was involved in this transaction a chance to state their side of the story, because I promise you now, I wouldn't be sitting here if it was they had given me that opportunity, because I would have explained to them that, in fact, we found out in 2017 that JM has sold the GPUs to Swissport, and then now Open Water is relying on the amount that the GPUs were sold for. And how I find out, Chair, because I thought I'll get this opportunity to state that. How I find out through the media. I had not even seen the report at that time. And that's why, if you had Friday, as much as I was not directing that point to Ms. Hofmeyer, because I know she's not acting personal towards me on this thing. She's on a mission, a fact-finding mission. At that time, I felt that this whole GPU thing was a way of getting to me in terms of because of the person that I am, because of what I was fighting for at that time, which of course had nothing to do with the GPUs. So I learned about the GPUs being sold to Swissport only in 2017. Remember, the board awarded this in 2016, and then I was instructed with my other colleagues to negotiate in 2016. But I find out that they were sold to Swissport in 2017 when I read the Sunday Independent. The article was written by Steve Mudale, and specifically crafted to paint to the public that Advocate Memela has been involved in the sale of GPUs. And of course, Chair, when the public reads, they think I have ran with the whole process from the beginning. Like as I said, this thing started from SAA, and I was not part of SAA negotiation. And it went to the board of SAT. I was not a member of the board of SAT. I only joined the meeting through an invite. So the way the article was written, it was written to paint a picture to the public that SAT had lost these assets and then money on it based on Advocate Memela's involvement. And then when I had to now explain during the disciplinary hearing to Advocate Kasim and also to CCMA, that's when it all started getting clear to everybody that actually Advocate Memela only started getting involved at the end of it all. You understand? Like, I mean, Chair, I'm just a small fish. I'm not above the board. I'm not above the CEO. The board is the accounting authority of SAT. CEO is accounting officer of SAT. But if you notice from 2017, like from the media, everything has been talking about Advocate Memela's involvement and stuff as if I was the one who was initiating this whole thing. And when I sat with the team, the commission's team, I remember Andrew, Mr. Ketland kept on saying it was in the media. You know, and I became worried again that, okay, it looks like we're going to go back again to Mr. Stephen Mutale's version of, painting the picture to the public that this is the person who's responsible, who was involved in the decision-making of this whole thing. Nobody is interested in the board resolution. Nobody is interested in the discussion from SAA, from the time when they discussed about offering 5-year period contract that was mentioned by Ms. Ufme on Friday to Swissport, and then like included the provision there that talked about the GPUs and the BEE company. No one is looking at the fact that there were a list of people there, top people, and then from the board of SAA, they had decided on the issue of Swissport and GPUs, and then it went to the board of SAT. They decided on the issue of GPUs and in fact on the issue of disposal of the GPUs. But the focus is on Nontsasa Memela because of the painted version that, okay, Nontsasa Memela knows JM this way because of that and that. So I'm glad that this question is raised this morning so that we'll be able to give that clarity and stuff. But like, for me, I thought, Chair, of course, as much as it's relevant to bring me here so that I give my own version, but I thought from 2017, this thing has been following the person who has never taken a decision about it. It has followed a person who was not even involved in the discussion about Swissport, you know, but because there's this link between JM and Nontsasa, and Nontsasa being the HOD SCM of SAT. So like the link is continuously it's being created. Yeah. So I'm saying, Chair, then when I got to know about the reselling by JM to Swissport, I got to know about it through the media. So like my statement made here, it does not mean that, oh, okay, we knew at that time that they were going to resell. Yes.
Well, that answer may have been important for you to give a full picture, but you need to go back to Ms. Hofmeyer's question. It may be that answer seeks indirectly to give the answer to the question. The question was whether you ever raised the issue of saying, you ever said to the people who were involved here, or to JM, whether you ever said, but a 30% set aside is unlawful, you know, it shouldn't be done. That was the question. Yeah.
Okay, Chair, I tend to talk a lot, giving the background.
Yeah.
I apologize for that, but I think the point that I was trying to make, Ms. Hofmeyer, is that at that time, remember, as I've said in my statement, we did not know there was going to be a resale, like from buying from SAT to resell to Swissport. So of course the 30% set aside issue was not raised at that time. Yeah, and we thought maybe they were going to, remember, supply development, Ms. Hoofmeyer, it does apply to BE companies given the subcontracting kind of work from these multinational or maybe these giant companies. So it could have been maybe when they buy the GPUs from SAAT, they were going to maybe operate them, like for what sad purpose what they were bought for, like on behalf of Swissport. So that was the understanding at that time.
Yes.
So it was the 30% set aside issue was never raised.
Okay, all
Yes.
right. Okay.
Thank you.
There may be times when I will restrict you.
Okay.
Your lawyer will know what areas might need clarification at re-examination stage.
Okay.
But let's continue.
So was your understanding that JM Aviation was acting as the agent for Swissport in the procuring of the GPUs?
Ms. Hoofmeyer, we don't call BE suppliers agents. The correct wording is SMMEs or small black-owned companies. Agent is something else.
Right.
So that our understanding was that then, because Mr. Nzegu at that time was the director of Swissport, and it appeared that he had joint ventures with Mr. Jules Air, who has been the supplier of SAT since 1992. And I want to mention again, Chair, before you restrict me, I'm not going to take long. My understanding, just like from Ms. Hoofmeyer's questions on the Swissport contract on Friday, that it appeared to me, in fact, as much as I complained that why should I answer something about Swissport, but it gave me light on something, that Mr. Vuyonzegu did not start operating or maybe having a business between himself and SAA. He's been on business between SAA and through Swissport as far as back in 2012 before I joined SAD. I may have known him during the roadshow, but he has known SAA long before me. Yeah.
Okay.
So just for a point of clarification, when you were dealing with JM Aviation about the sale of the SART GPUs, did you know that Mr. Nzeku was a director of Swissport, South Africa at the time?
He had mentioned, I think, during our discussions, I did mention to you that after the roadshow,
yes,
we had talked a lot, to an extent where we talked about other things that had nothing to do with SAT.
Yes.
So he did.
Right.
Yeah.
But
on Friday, when you were talking about that, I had forgotten.
No, that's
that.
fine.
Yeah.
That's helpful for us to know that you were aware of that.
Yes.
The reason why I asked about the role of JM Aviation as an agent is because the actual clause of the Swissport SAA agreement that you were implementing as SART in the sale of the GPUs doesn't refer to any entities other than SAA and Swissport. Mm-hmm. You'll recall, I'll just read it to you. If you want to go to it, I can give you the reference.
No, I understand.
I just want to read it into the record. Mm. It says the handling company, that's Swissport, as defined in the agreement, agrees to purchase and or arrange the purchase.
Just to remind myself, Mayor,
Sorry, Chair. I understand from the transcribers that when Ms. Mbanjwa makes an objection, she needs to come to the podium because otherwise it won't be caught.
Yeah. What you can do for the future, Ms. Mbanjwa, is to raise your hand, then I will know that you wish to say something, then you can come to the podium.
Thank you, that would be helpful, Chair. It's not an objection, Chair. I just wanted to remind Ms. Hoofmeyer that if she can please give the page references.
Yes,
she reads
for your assistance. I think she was going to give, I'm sure.
Indeed.
Yeah.
Of course. I was just indicating whether Ms. Memela wanted to find the page, and then I was going to indicate for the record where we were.
Yes.
I'm reading from Exhibit DD25A at page 316. That's the page that contains clause 8.2 of the SAA Swissport agreement.
Yes.
And we had looked on Friday at the provisions of clause 8.2. It reads as follows: the handling company and I pause there just to assist, that is Swissport under the agreement, agrees to purchase and or arrange purchase of all recently acquired surplus SART GPUs at current book value, fair market value, or other such valuation as mutually agreed. Do you see that, Ms. Memela?
Yes, can I ask, Chair, for Ms. Hoofmeyer to read from 8.1 as well?
Certainly. 8.1 says, as part of the continuous improvement of its triple BEE and promoting the government's development agenda, the handling company, that's Swissport, will subcontract some of its services or enter into agreements with 51% black-owned companies that have the representation of all or either of women, youth, disabled persons and military veterans for the purchase of equipment required as part of its investments to this agreement.
Yeah.
And then it goes on at 8.2.
Good.
And my question was, when you were dealing with JM Aviation, you indicated you didn't regard them as Swissport's agent, correct?
Yes.
So in a provision like 8.2 that says the sale is going to happen between SART and Swissport, how does JM Aviation enter the terrain then at all?
Okay, I understand that you have the email from Mr. Jules to Mr. Malola Piri. Do you have that?
Yes, we do indeed.
Yes, can you direct me to that, because I want to read it for record.
Certainly. Just before we go there, what I'm interested in is your understanding of the provision. So if you'd like to go to that email for that purpose, I'm happy to direct you.
I'm going that for that purpose. Thanks, Chair.
Thank you.
If it might take time to find, your junior could look for
Indeed.
it and you deal
I think
with
we'll
other
need to do that.
questions and come back to
no,
it later.
It's all right, I have it in front of me.
Oh,
I just
okay.
sometimes have to remind myself which of the two bundles we're
Yes,
in.
yeah.
You'll find it in Exhibit DD25B at page 607.
607. Or the additional file? Is it
Yes, it's in the B file, indeed. DD25B at page 607.
I got it, Chair.
Thank you. So just to remind you, the question was, in what role did you understand, or in what capacity did you understand JM Aviation was interacting with SART insofar as the sale of the GPUs was concerned, when the only agreement was between Swissport and SAA for the purchase of the GPUs?
Is it me or your question has just changed? Or maybe the wording has changed?
I don't have the ability to repeat exactly the words I used 10 minutes ago, so I'm trying to just convey the essence of the question, so that when you draw us to the email at page 607, you understand the background from which I've asked the question.
Okay,
Would you like
Chair.
me to repeat it, or are you comfortable?
Okay, Chair. I would like to state on record how I understood her question to be.
Yes, that's fine.
Which led me to come to this email. Was
Okay.
that
Well, if you like, you can indicate this is how you understood the question earlier and this is your answer.
Yeah.
And
Okay.
that may or may not coincide with the question as formulated after.
Okay. How I understood her question, Chair, was that she wanted to find out from the provision that she read, provision 8.2 of the contract, because it does not talk about a specific BEE company. It talks about between SAT or SAA and Swissport contract. How did I find out, or maybe conclude, that JM was one of the agent or the BEE company, right? I think that was my understanding, because they were not mentioned in this provision.
Yes.
Okay. So that's the reason then, Chair, that I thought this email
You wanted this email, yeah.
is relevant. The email, Chair, was written in April 2016.
It's April 26,
Yeah, we go back then to
Yeah.
page 608, Chair, before we get to 607.
Uh-huh.
My understanding, it was written at the same day. So it was written by Mr. Jules A. To the then acting CEO of SAT, Mr. Asin Malola Piri, and copied Mr. Musa Zwane, who was the CEO of SAT but was acting at SAA at that time, and then copied Miss Sokulu, Miss Kosi Sokulu. And the subject, Chair, says formal purchase offer of his Singer diesel ground power units, model MDE 18 kVA. Now, Jules says, Dear Asin Malola Piri, in accordance with the Swissport contract recently signed with SAAT, here I think, Chair, he meant SAA because the Swissport contract was between SAA and Swissport. We are offering to purchase the quantity 12 of the ground power units. We will accept the units in as is where is condition, and SAT will not incur any further costs. Purchase price 225,000 each. Total purchase price will be 2,700,000. Please, can you arrange for me to inspect the units at SAT? We look forward to your acceptance of our formal offer. Can you please confirm receipt of our formal offer? Now, this email, Chair, is coming from the CEO of JM. This is before Mr. Malola Piri goes to the board with a submission requesting to sell the GPUs. Mr. Asin Malola Piri responds, Dear Jules, I'm in receipt of your email below, reformal purchase offer in respect of SAT GPUs. Whilst I understand the provision made in the Swissport SAA contract in respect of sale of GPUs, it is incumbent on SAT to follow due asset disposal process, which will include SAT Exco and board approvals. If there are compelling merits to sale as opposed to leasing out, SAT will submit a business case motivation to dispose of the GPUs at the board meeting scheduled for the third week of May 2016. Should it be approved, I will engage with JM Aviation Limited for conclusion of the transaction. Hope you find this in order. This is the response from the then acting CEO of SAT. So, Chair, the reason why then we understood that JM is the BE company of Swissport, it was through this email. Because, as I remember I said on Friday, we got an instruction from the acting CEO after the board approval of the sale of GPUs to sit with JM Aviation and negotiate the offer, which the offer was sent to Mr. Asin Malola Piri April 26 before the board meeting. And then he referred to it that these are the processes that are going to be followed. And then once the board approve and EXCO approve, we will then come back to JM, which is going back to JM. He did that through myself and the colleagues when he said we should negotiate the deal.
Okay.
So I hope I've answered. If I've left something out, you can actually add. Yeah.
Certainly, I'll follow up there. Thank you so much. I understood your evidence to be you didn't know until 2017 that JM Aviation then sold the GPUs to Swissport. Is that correct?
I had found out then that they were sold to Swissport through the report that was coming from Open Water Report, but I found that out from the media, Sunday Independent, written by Stephen Mudali.
So the answer is yes?
Yes.
At the time that you were dealing with JM Aviation in 2016 then,
yes,
what did you think they were going to do with the GPUs after they bought them from SAT?
As I've said on my statement, Chair, or maybe earlier this morning, I said our understanding, and I did mention on Friday that during the meeting there was the owner of the GPUs, Mr. Chaile Makaleng. He heads the department that owns the GPUs. And then there was Mr. Stan Foslow. And both these guys are technicians, former technicians, and they know the technical part of things. For me, I was sitting there to ensure that, okay, maybe SAT gets value for money, although I wouldn't do it to the best of my ability if we don't go out on a tender, since the board had already decided. Yeah. Okay, I forgot. You see now, this thing of talking too much. I forgot the question.
Yes, let me give you the question again.
Yes.
What did you understand JM Aviation was going to do with the GPUs after it bought them from SART?
Okay. My understanding at that time, Chair, was that they were going to maybe operate them for the purpose they were bought for. Because remember, the reason SART bought these GPUs was that they were going to provide those services to Swissport. But later on, when the contract was never signed, as mentioned by Ms. Hofmeyer, from 2012, they were used for another purpose, not the purpose that they were bought for. Yes.
Okay.
So you had no understanding that they were in fact acting on behalf of Swissport when they purchased the GPUs?
Okay, come with simple English.
It was not your understanding
Yeah.
that they were acting on behalf of Swissport
Okay.
when they got involved with the purchase.
Chair, my understanding was that they were buying them as the BEE company of Swissport, and then maybe they will operate on the subcontracted part of things, where they will then be operating the GPUs for what SART was going to use them for when they were initially bought in 2012. So that was my understanding.
Thank you. Let's then move to the board resolution, Ms. Memela, because I do understand from your evidence, and you emphasized this on Friday and you've emphasized it again today.
Yes.
You did not take the decision to sell these GPUs for SART.
Yes.
And in fairness to you, I want to take you to the board, the minutes of the board meeting at which the board, not you, made that decision.
Okay.
Let's go to it if we may, because part of your concern earlier, as I understand it, is that people have drawn links between yourself and this arrangement that are unfair.
Yes.
And I want to say to you, we are going to remain faithful, not to media reporting, but to documents and your evidence in the course of today's proceedings.
I hope so.
So let's do that. Let's go to DD 25B. It's the smaller bundle in front of you. And if you just go over the page to page 609, you will see the minutes of the meeting of the SART board. Do you have that?
This is, Chair, the extract of the meeting, of the minutes, of the main minutes.
Yes.
So just for the Chair's understanding, Ms. Hofmeyer, I don't know if you remember, I sent you the full minutes of that board.
Yes.
Because now, if we read this on record.
Well, wait for her question.
Oh,
Wait
okay.
for her question,
All
because it does say at the top the extract
Of the minutes.
from the minutes.
Yes.
So we know that it's not the whole minutes.
Okay.
Yeah.
Let's do it this way. This is the extract dealing with the item on the agenda for that meeting, which is the disposal of the ground power units.
Yeah.
If you regard any other provision of the minutes as relevant, you'll direct us to them in due course. I'm interested in the decision that was taken at that meeting by the board of SART related to item 4.4, which is the disposal of ground power units, the matter that we're concerned with the Commission today.
All right.
It records there in the first paragraph, the board was requested to consider and approve the disposal of 12 ground power units as the services they were purchased to offer had been outsourced to an external service provider, Swissport, by SAA. Before I continue, can I just confirm, you were not in attendance for the whole of this board meeting on the 15th of June 2016, were you?
I was not Chair. That's why I think I wanted to go to those minutes, because they are very detailed, but it's fine, we'll go to
I
that.
was not is enough as an answer.
Indeed.
Yeah.
But you were invited to attend, and were you there for the conversation and debate around the disposal of the ground power units?
As much as I don't remember correctly, but like I know that I was only invited for, I think, logistics discussion.
Another item.
Yeah, logistics
agenda.
item, yes.
So you are not sure whether you were there when the board discussed this item?
Yes, but I do know that it was tabled before I think I walked in.
Yes. Okay.
And did you familiarize yourself after the meeting with the decision that the board had taken in relation to the ground power units before you got involved in negotiating their sale price?
Okay, Mr. Malola Piri sent us the board resolution and not this extract of the minutes.
He
The
gave you
board
the minutes.
resolution. Yes, no, he gave us the board resolution.
Okay, all right.
Yes, not these extracts.
Okay.
Yes.
So is today the first time that you're seeing this extract?
No, today is not the first time. The first time I got to get this is when I was actually going to defend myself during the disciplinary hearing and at the CCMA.
Right.
So I dug all the information that I could use. Yeah.
And the next paragraph reflected in these minutes of the meeting of the SART board on Wednesday, 15 June 2016, is as follows, and I quote, "It was reported that the GPUs would be sold to Swissport at their current asset value. The board was informed that SAA's contract with Swissport provided for Swissport to purchase the GPUs from SART." Then goes on and records, "The submission proposed that SART should consider whether to recover the difference between the purchase value of the GPUs and the current asset value from SAA. The ICFO and GMLRC indicated that SART had been utilizing the GPUs whilst SAA was resolving its contractual issues with its ground handling service provider. Therefore, the reduction in value of the GPUs was due to depreciation and was not a loss." And then the resolution is recorded. "It was resolved that the disposal of SART's 12 diesel-operated ground power units, GPUs, as a result of SAA awarding the ground handling services to an external service provider, be and is hereby approved."
Chair, can I ask Ms. Wolfmeyer to go back to the third paragraph where it starts from the ICFO? I know people who are listening, they don't know what those abbreviations are for.
Yes, but
So, yeah.
hang on. As she asked you a question, I think wait until she asks you a question because everything we do must relate to the questions. If after she has asked questions in your answer, you think it's important to draw attention to that, then we can go
Okay.
there. Yeah.
Thank you, Chair. So that was a recordal of both what had been conducted in the course of the meeting as well as the resolution that the board took. And as I understood your evidence earlier, you were then provided with the resolution itself. Is that correct?
Yes, yes, Chair.
And after that point, Ms. Memela, I understand your evidence to be you were then tasked with negotiating the sale price for the GPUs. Is that correct?
Myself, the HOD for the department that owns the GPUs.
That is Mr.
And
Makaleng.
Mr. Makaleng and Stan Forslow.
And Mr.
The only
Forslow.
person who could not make it to that meeting was Mr. Leon Roberts.
Thank you. So we'll come back to that. That's the meeting of the 21st of June, 2016. Is that correct, that you're talking about?
I don't remember because we don't have the minutes for that. So I would agree it would be that.
Thank you. There's an email that is sent to you after the meeting by Ms. Sokulu,
Yes.
which talks about the meeting that day. That's what I'm basing my suggestion that it's the 21st of June meeting. Okay, so let's go through what you did after this board resolution was taken to now negotiate the price.
We now go back to her affidavit.
Well, it's going to be a few documents I'll take you to,
okay.
Chair.
All right.
I want to know, first of all, whether you went and found out what SART had purchased the GPUs for the year before.
You want to know if I had to go and find out if SAT had, how much they have purchased the GPUs for?
Slightly different. I didn't ask whether you had to. I asked you first whether you did.
Did I?
Did you
Okay.
go and find out what SART had paid when it bought the GPUs the year before?
Okay, Chairperson, remember the board resolution talks about the book value. Myself, together with the owner of the GPUs and Mr. Stan Forslow, we did not go back to the time when the GPUs were bought. And the reason for that is that for that moment as well, there was no tender that was the site went out to buy the GPUs. They negotiated with this specific company, and no one is sure that for whatever amount that they bought them for, SAT bought them for, was the correct amount, because there is absolutely no proof that they had negotiated the amount, or they just bought the GPUs for what the board had approved for. Because my understanding is that sometimes the board would approve 500 rand, and then from the procurement point of view, it is your duty to go and negotiate and try and save as much as you can. So I think the reason at that time that we did not want to go back to that is because the board had approved for the specific amount, and then the people who bought these at that time bought them exactly for the amount that was approved by the board. It did not really sit well with us, because like relying on that at the end of the day does not determine the price or the amount that they should be sold for. That's the reason why I wanted to go back to where the interim CFO at that time and the GM legal made that statement. But Chair, we did not go, the response is that we did not go back to that. We relied on what was there in the book value at the time. And I did mention, I don't know, maybe it's not in the documents here, I did mention that the system that SAT was using was outdated long time ago, with software that is outdated. So the book value, whatever that was put there, was not really realistic. So we had to rely on other,
Okay, so can I just make sure I understand? You didn't look at the purchase price from a year earlier because you were concerned that that didn't represent fair market value. Is that correct?
Yes, it did not really represent the fair market value.
Thank you.
Yes.
And then you started talking about the book value.
Yes.
Do I understand your evidence to be you did consider the book value?
The book value was considered looking at the MEMIS record, and I think maybe it will be from Mr. Chaile Makaleng, and also checking with the finance. Remember, Chair, during the board meeting, that's the reason why I wanted to go to the full minutes. There was a CFO of SAT sitting there.
Yes.
Remember, the asset register is maintained and managed by finance.
Yeah.
So my understanding, him sitting there with the acting CEO submitting to the board what he was submitting being the book value or whatever, versus what is actually in the asset register and book value. Yeah. So.
Well, we can go to those minutes if they are here, if that will assist you to give
the response.
An answer that
yes,
you want to
I
give.
request we go to that, because
Yes.
I think it will give a clear clarity of
You'll have to
what I
find them, Ms. Memela. They were, I understand you to say they were amongst the annexures that you provided to the Commission, but I explained at the outset of your evidence that they had never been identified with cross-reference to your statement. So they have just been assembled for your benefit after your statement, but I am not on top of those documents, so we'll need to find them. I'll ask my junior to assist me.
Okay, so what we'll do, Ms. Memela,
Yes, Chair.
Mr. Mbikiwa will try and look for them. Your own lawyer will try and look for them while we continue with other questions.
Yes, sir.
And then at a later stage, we'll come back to the question once somebody has found them.
Okay.
Ms. Memela, can I just get clarity though? I understood your evidence earlier to be you hadn't seen the minutes of that meeting at the time that you were negotiating the sale price. I understood your evidence earlier to be you only saw them much later when you were preparing for your CCMA case. Is that correct?
That is correct.
That's very helpful, because then anything that's contained in the minutes is not going to assist in understanding what was in your mind and what you were doing at the time that you were negotiating. Is that right?
No, that's not right. That's not my understanding.
Okay.
Okay, let's try and get that out of the way. Ms. Memela?
Yes, Chair.
I think you are looking for the minutes. Let's stop looking for the minutes for now.
Yes, Chair.
So that we can continue with other questions. But your lawyer and junior counsel to Ms. Hofmeyer will be looking for those minutes in the meantime. you must just remember that at some stage, we go back to them if it's necessary.
Okay.
But I don't understand your answer to Ms. Hofmeyer when she says, if at the time you were not aware of the minutes, whatever is in the minutes could not have been a factor in terms of your understanding, and you say, no, that's not right. Do I misunderstand something?
The reason I put it like that, Chair, was that what is written in the minutes is supporting our understanding at that time. As much as we did not see the minutes, but like that was our understanding, myself and the colleagues that were sitting during the negotiations.
No, that's fine. So it's not that you were aware of the minutes at the time.
Mm-hmm.
It's just that you had a certain understanding,
Okay.
and subsequently you saw something in the minutes that supports your understanding.
Yes, Chair.
That's what you say.
That's
Okay,
what
all
I'm
right. Ms. Hofmeyer?
Thank you, Chair. Ms. Memela, do you accept that the acting SART CEO thought that the book value of the GPUs was relevant to the price at which they should be sold, given what he included in his submission to the board?
Yes, the book value that was put by Mr. Malola Piri was in the submission
Correct.
before the board. I agree.
Yes. And let's just look at what the book value was at the time. You'll find it in your DD25B bundle, and it's at page 611.
611.
Yes.
What I have at 611 doesn't appear to look like what you have.
Yes, I'm also worried.
Oh, no, I think what you have in your hand is what is different from what I have, but what you have on the next page.
Yes,
there
is
seems
your
to be-
611. Oh, goodness.
Yeah, it's my
that's
611.
very worrying. Well, I think there's another location for this in Mr. Human's affidavit, because he was taken to that. Maybe what I do for now is just read it into the record. I'm concerned that there's a difference in the pagination.
Yes.
But it was an aspect that he confirmed in his evidence before the commission. Ms. Memela, if you would like to...
Yes, I think Ms. Mbandwa wants to say something.
Thank you, Chair. I just wanted to put on record.
Come closer to the mic, otherwise you won't be recorded.
Thank you, Chair. I was also looking at the reference. I do not see the book value, so I wanted to point out that what I've been referred to in the record is not what Ms. Hofmeyer
Yes,
is talking
okay.
about.
Okay. If it's possible, it might be helpful if you sat much closer to Ms. Hofmeyer,
Yeah.
subject to her own stuff there, because sometimes you can just whisper to her something or make a note and give to her.
Chair, can I
Yeah.
be problematic?
Yes.
I'm just about to direct Ms. Mbanjwa to the Human bundle, which I
Oh.
see is in front of her, and it's very difficult to move.
Okay,
So
okay.
if just for
All right.
now,
Yeah.
because I want everyone to have the document in front of
Yes,
them, certainly.
yes.
There seems
Okay.
to have been some error between my copy of Ms. Mamela's bundle.
Yes.
But it's not a problem, because we have the very same page in the Human bundle.
Yes.
Because as I indicated, he testified about it earlier in the week. And
Okay.
Mr. Human's affidavit and annexures had previously been provided to Ms. Mamela.
Yes.
So where
But
we need to go.
before we do that, that box, the second box between you and Ms. Mbandwa, does it
Yes.
have to be there? Because if it can be removed, she could come closer.
That's preferable. Let us do
Because
that.
some of the issues, you could just make a note for you, bring something to attention without us
Indeed.
stopping the proceedings.
Indeed.
Maybe let's try and do that, and even all of those can still be brought closer. It's just going to help with the smooth running of the proceedings. Of course, you do need to have your staff there,
Indeed.
but I think that will help.
I'm certain it will.
Yeah.
Yeah, Chair, if I can request Ms. Hofmeyer, can you direct me which file that?
I was about to,
Okay.
indeed. So, Ms.
So,
Memela?
yes, so,
and-
I'm sorry, Ms. Hoffman. So sometimes you can just make a note and bring it to her attention, and she can take that into account. If there is a problem, she will say, okay, let's stop, and then you can articulate. But sometimes she will be able to address what you are saying without us stopping the proceedings. Okay, all right.
Thank you, Chair. We're indebted. The second copy of the same document is in Exhibit DD 22B. That's the second file of Mr. Human's bundle, and you'll find it there at page 694.
Just repeat the bundle.
DD 22B
Can you
at
see
page
it, Ms. Memela?
694.
Yeah, okay.
At page?
694. This is an extract from the asset register as it was in June 2016. Do you see that, Ms. Memela?
As it was in June 2016.
Correct.
Chair. Not to be problematic or anything, I see a document that was done in an Excel spreadsheet, and then with something written June 2016 with somebody's hand, and then it's got some signatures in the corner, which does not really say who signed. Was it the person who's responsible for asset register or not? But that's what I see. And my understanding in asset register should be as formal as possible, as much information as possible. And this, to me, this is exactly what I had disputed at the CCMA and during the disciplinary to Advocate Kasim, and which he accepted that this cannot be accepted as a formal asset register, because anybody could have put whatever that they want to put, and it was only the representative of the employer who had that at that time. So I'm not sure then if Mr. Who signed this, who was managing it at that time and whatever.
So you say that you see a document here, but you can't accept that it reflects what was in the asset register. Is that what you're saying?
Yes, I'm saying also, Chair, remember the book value should rely on the system, which was MEMIS at that time. So there is no attachment maybe that is coming from MEMIS that states how much did MEMIS say at that time in the book value, yeah.
Ms. Memela, you never saw this document when you were negotiating the sale price, is that correct?
No, definitely not, Chair.
Okay, hang on. Ms. Mbandwa?
Thank you, Chair. I also have an objection to the document that has been presented, because there is an email that was produced. I just want the page of the email. And in the email, these ground power units were given a name. They were called Hish something. I just want to get that email.
Well, I think what you may wish to do is make a note. Let's see what Ms. Hofmeyer's response or reaction is to the answer given by the witness. And bear in mind that clarification could be given later.
I think, Chair, I may have to be guided because Chair has said this commission has been sitting for 1.5 years, apart from the very lofty position that Chair has in the judiciary. What Ms. Hofmeyer is doing, the way I see it, she is making Ms. Memela answer questions on a document. The correctness thereof is not acceptable to us. Or to put it in another manner, all I want Ms. Hofmeyer to do is to say at least that these assets that are described here are the GP units that we are referring to. That is basically our objection.
Yes, no, I'm saying the witness had just given her answer, and I don't know if she had finished, and Ms. Memela Ms. Hofmeyer had not had a chance to respond, to react to the answer. The reaction to the answer could be, yes, I understand what you say, but there's another document, I'll take you to that document. At some stage, the reaction could be, no, maybe you are mistaken, Ms. Memela, about this document. So let's go on and let's see. Yes, you are premature. Okay, thank you.
Chair, I was just about to finish then, and then.
Oh, you had not finished your answer?
I had not finished.
Yeah, that's the point I'm
Yeah,
making.
but I'm not going to take long.
Yeah, just finish your answer.
Just for the Commission's understanding and for record, I just needed to, I know, am I allowed to ask an evidence leader? Because I want to understand this document in front of us. Clarification.
Ask for clarification.
Yes. I would like to ask Ms. Hofmeyer, there are dates here that are under capitalized on. I just want clarity on that, if you understand what those dates were.
No, I wasn't employed at SART at any point.
Okay. You see now.
Well, let's go back to the question. Okay, I think just stop there.
Okay.
Too much has happened since the question was asked.
Yes.
Let's go back to the question, Ms. Hofmeyer. I just want to...
Yeah, because I just need a clarity, Chair, on the June
make
2016
sure.
one.
Hang on.
Oh, okay.
Let's go back to the question. You listen to it and you give a crisp answer to it.
Ms. Memela, you confirmed you had not seen this document before you engaged in the negotiations of the GPU sale price, correct?
Yes, I confirmed.
Thank you. I don't need to deal with the document any further then if you didn't see it at the time.
Oh, so that's
what I'd then like to go to is the submission that Mr. Piri, who was the acting CEO, prepared for the board before it took the decision to sell the GPUs, because Mr. Piri spent some time looking at the book value of the GPUs and made submissions to the board about what the book value was. So if we could go there.
Sure.
Yeah.
I feel that it's too easy, or maybe it will not give clarity to the public, or I mean, people who had read about this whole thing in the media. And I'm glad I see NUMSA is here. They've been quite interested in this GPU issue. If Ms. Hofmeyer decides not to deal with that document, because I've had a relevant question asked about the dates. Remember,
yes.
when Open Water reached a wrong conclusion on this matter, I'm still going to add that they actually even used the wrong provision of the SCM to reach their conclusion.
Yes.
So their conclusion was based on this documentation. That's why I said I actually only started seeing this during my disciplinary hearing.
Yeah.
And then at the CCMA, where I had to actually defend myself and clear myself from this whole thing.
Yes.
But now, if when I ask a question, maybe, and then because there are no answers, like as Ms. Hofmeyer said, I was not the employee of SAT. Remember, she was going to use this as evidence.
But
And now...
hang on, Ms. Memela.
Yes.
I understand your concern about maybe certain aspects not being asked or not being dealt with to your satisfaction at a particular point in time. But she is there to lead evidence in regard to what's relevant and important to the Commission.
Okay.
It may be that some things that she regards as relevant and important to the Commission are not the same things that you regard as important and relevant to be dealt with. But where she asks you a question and to answer it, you need to look at a document. I will allow you to do that, subject to the ambit of the question. But your lawyer is there to keep an eye on some of the things that she knows, having consulted with you, may be important for you. And that at a later stage, when she gets an opportunity to re-examine, she could then look at some of the answers you had given and give you a chance to clarify.
Okay.
So.
Fair enough.
Okay, all right.
Yes.
Okay, thank you.
Chair, just in explanation before I move to the next question, the part of the evidence that we're interested in at the moment is Ms. Memela's role in negotiating the sale price.
Yes.
It is for that purpose that I'm seeking to establish through the questions of Ms. Memela what she knew at the time. When Ms. Memela indicates to me she didn't see a document at the time, I must leave it.
Yes,
because
yes,
it was
yes.
then not something that was weighing on her mind. I've now moved to the next place where there was an indication of what the asset value was, because I'm then going to ask Ms. Memela whether she had that knowledge at the time. There's no intended unfairness. I can't persist in a line of questioning with a witness where I'm trying to establish her state of knowledge at the time. When I present her with a document and she says she did not see it at the time, I must then move on with your leave, Chair. And so I move on to Exhibit DD22B, and that is the Himan exhibit, and if you pick it up at page 811.
I see we are at the time that when we normally take the tea break. I propose not to take the tea break unless either the witness or you, Ms. Hofbeer, need some break, because we are going to have an extended lunch today because I need to attend to another commitment in my other capacity that is urgent. So our lunch will be longer than normal, maybe 2 hours. So I want us to use this tea break if we can. But if either the witness or Ms. Hofmeyer, because they are the only ones who can't sneak out while we are, if they are fine to continue without a break, we will. But if one of them wishes to have some break, then we will have a break. Ms. Memela, you would like to have a break?
Yes, Chair. The reason why I'm raising this without my lawyer is that, remember on Friday, I had mentioned that I was supposed to drive down to Eastern Cape, and we had asked for Monday maybe to use 2 to 3 hours, but I wanted to inform you that we are okay with the all day, so you don't have to be under pressure as long as everything when we leave here is as clear as possible. Yes.
No, thank you very much for that. Thank you very much for that.
And Ms. Memela, are you happy to proceed?
You don't have a problem.
In a break, we do need it, Chair.
You need some break?
Yes.
Okay.
Yeah.
Okay.
Chair, if I may make the request then, just in the break, if Ms. Memela could find the minutes she was looking for. We haven't been able to find them in the annexures that she provided, but she can obviously use the break just to go through them and assist us with where they are in the bundle. And then when we return, we'll deal with the SART CEO submission.
Okay, then we'll take the tea break. It's 20 past 11 now. We'll resume at 25 to 12.
Okay, Chair.
We adjourn.
All rise.
would like us, as far as possible, to try and have a smooth running session. Now, that doesn't mean, Ms. Mbanjwa, that if there is something you feel strongly about, you shouldn't raise it. But I would like all of us to try. Ms. Memela, this is also directed at you. I would like us to try and run as smoothly as possible. In the process, I would like you to try to give crisp answers, short answers to short questions. Ms. Mbanjwa is there she knows your story. She has taken instructions from you. She will be alive to some things that you might wish to have clarified later on.
Okay.
But apart from that, when you are done, when Ms. Hofmeyr is done, either before Ms. Mbanjwa re-examines you, I will give you a chance to deal with other matters that are relevant to some of the questions which you think might be part of putting your case properly to the Commission. Okay?
Thanks,
But I would like us to go quickly and smoothly with regard to questions and answers. And the shorter the answers, the better.
Okay.
Okay. Thank you.
Thank you,
Ms.
Chair.
Hofmeyr?
Before we broke for the tea adjournment, we were going to be looking at Exhibit DD22B at page 811.
I think I'm looking at a wrong one.
I think Swinsley is assisting. Thank you. Page 811 of Exhibit DD22B. Ms. Memela, what is this document?
Chair, this is the SAT board submission.
And who is it compiled by?
Based on the signature and based on who is it from, it's acting CEO, SAT, Mr. Asen Malola Piri.
And the date of the document?
The date was 15 June 2016.
We saw previously the extract from the minutes indicated that the board meeting was also on the 15th of June 2016. Does that accord with your memory?
Yes, Chair.
Let's go, if we may, to the bottom of page 812. You'll see there at the bottom 812, there's a heading under 6, financial implication. Do you see that?
Financial implication, yes.
Could you read into the record what Mr. Piri, the acting CEO of SAT, recorded under financial implication?
Okay. Financial implication, each unit was purchased at a cost of 766,165, each with a total cost of 9,193,961, is it 981? 20 excluding shipping costs. The current value of each unit per SAA asset register is at 682,890.62. Selling the units at current asset value should realize an income of 4.7 million.
4,780,000.
4,780 to 3140.
Yeah.
Thank you. Ms. Memela, it appears from this document that Mr. Asen Piri, the then acting CEO, did have cause to look at the asset register and reflect the amount in the asset register. Do you agree with that?
I would think so, because this amount that he has written here is the same as what was written there on the asset register that we rejected. That was written by hand 2016, although it has.
No, it's actually different. But we don't need to go back to that document.
Around that amount, yeah.
Yes. So his amount here having looked at the asset register, is 862,890 rand and 62 cents per unit. Correct. Now, did you have reason to discuss with Mr. Piri what he had said in his submission to the board? Oh, sorry, Chair, I see there's an objection.
Oh, okay.
Thank you, Chair. The basis of the objection is the fact that what we asked when we objected for the first time, Chair, is to say, let us have a proper asset register so that the questions then can pertain to the proper asset register. This is still not a proper asset register. And Ms. Memela has been asked to authenticate this document as if it is her document. She is not the author of this document. Therefore, she cannot confirm the correctness of the contents of this document. Otherwise, that is prejudicial.
No, my understanding of the question was that she was supposed to just give her own understanding. I don't think that there was really a problem. But make a note, when you re-examine, you can clarify all of those things.
Thank you, Chair.
Okay.
Ms. Memela, were you aware that the acting CEO had indicated to the board through the submission on the 15th of June 2016 that according to the then asset register of SART, each unit's value was 683,890 rand and 62 cents?
No, Chair, I was not aware. When the acting CEO gave us the instruction to sit and negotiate the proposal, what he gave us was the proposal, that one page that talked to the GPU equipment, like from the SAA Swissport contract, plus the board resolution. Yes, Chair.
Thank you.
And
Well, I must say, Ms. Memela, your answers are very crisp now.
Yeah, I'm trying, Chair.
Yes, no, you're doing well.
Thanks, Chair.
Thank you.
And then let's move to the meeting that you had on the 21st of June, 2016. I understood your evidence previously to be that Mr. Makaleng and Mr. Vosloo attended that meeting with you. Is that correct?
That's correct, Chair.
Ms. Memela, both Mr. Makaleng and Mr. Vosloo have given affidavits to the Commission in which they deny having attended those meetings. Mr. Makaleng's, I'll take you to in a moment, is already in your bundle. Mr. Vosloo's affidavit came through this morning, Chair, so it was added to the bundle this morning, but he has subsequently, just in the course of the hearing, identified 2 typographical errors in his affidavit, and so he's provided a further supplementary affidavit. I'd like to beg leave just to hand those in, if I may.
Yes.
They've already been paginated. They'll come at the end of Exhibit DD25B, and they are paginated from page 742. They've been paginated already.
The affidavits of Mr. Stanton Leonard Vosloo and that of Mr. Both of these are Vosloo?
Yes, they are indeed.
Oh, okay. Are admitted and they will be added to Exhibit 25B and they will run from page 742 to page 750. Is that correct?
Indeed, Chair.
Okay, all right.
We're indebted.
Thank you.
Apologies, 751, I understand, Chair. Goes right to 751.
Oh, yes, tab to 751.
Thank you.
Thank you.
Ms. Memela, do you maintain in your testimony to the Commission that despite the fact that both Mr. Makaleng and Mr. Vosloo say that they were not at the meeting on the 21st of June, that they were at the meeting?
I maintain, Chair.
Right. Let's look at the proof that Mr. Makaleng provides for having not attended the meeting. And if you'll find that in DD25B at page 630.
1 second. B.
630. 630, Chair.
630. Sorry. Remember, I have to put this in the right place. 630, yes.
Chair, that is the first page of Mr. Makaleng's affidavit, and I'd like to draw Ms. Memela's attention to one or two aspects of the affidavit.
Sorry, Chair, I'm not there. Is it the file of Mr. Human or
No, it's
my
your file. So DD 25B,
Well, Miss Memela, I think we were on the same. I was having human bundle as well. So
apologies, these,
I just got rid of it.
there are far too many A's, B's, C's, etc. We are in Ms. Memela's bundle. That is for the record Exhibit 25, and we're in the B volume, and we're looking at page 630.
Yeah, I'm there, Chair.
Thank you. So the affidavit commences at page 630, and what Mr. Makaleng goes on to deal with at page 631 is his involvement in the sale of the ground power units. There are just a few paragraphs I'd like to highlight and then ask for Ms. Memela's comment. We can pick it up at paragraph 7 on page 631. What Mr. Makaleng says at paragraph 7 is, I was requested in early 2016 by Mr. Arson Malola Piri, who was the acting chief executive officer for SART. He emailed me and instructed me to prepare a submission for the sale of the GPUs. This was not something I was in favor of, as can be seen in the example correspondence in Annexure CM1, but I prepared a draft submission as instructed. Mr. Makaleng goes on to explain how he had first drafted the submission to suggest selling only 7 of the 12 units and retaining 5. But the relevant next paragraph I'd like us to look at in its own words is over the page at 632. Over the page at 632, Mr. Makaleng, in his affidavit, says the GPU value I included in the submission was 682,890 Rand and 62 cents each, which came out of the asset register at the time, subject to depreciation. Chair, I just pause there to indicate for the record that's the same amount that was included in the submission that the acting CEO then gave to SART that we've just looked at. And then he goes on at paragraph 13 to say the following. He's talking about the meeting scheduled for 21 June. He says, and I quote, I did not attend this meeting, which was scheduled for 21 June 2016 from 11 to 12. I did not accept the invite that I would attend the meeting because the invite to this meeting was sent to me at 9:09 on the 21st of June 2016, at which time I was attending our daily operations meeting, in brackets delay meeting, which starts at 9 to 10:30, and would not have been able to see the meeting invite in time. I was also not in favor of the transaction and would not have attended the meeting to dispose of the 12 GPUs. I have not attended any meeting with JM Aviation representatives to discuss the sale of the GPUs, nor pricing at any stage. I have also not attended any SART internal meeting to discuss the pricing of the GPUs to be sold. There is a reference in that paragraph to an Annexure CM4, which I'd like to take us to, because that is the meeting invite which Mr. Makaleng attaches to his affidavit. You'll find that at the same volume, DD 25B, at page 647.
Page?
647. Mr. Makaleng explains, is the meeting invite that he received. Ms. Memela, can you indicate the date reflected on that page from the calendar of Mr. Makaleng?
The date
Yes.
is 2106 June 2016.
Thank you. And then if you look at the bottom right-hand corner, there's a box there that says GPU discussion. Do you see that?
Yeah.
Do you see that it gives a start time? What is the start time of that discussion?
The start time 11 o'clock,
What is the end time?
12 o'clock.
Who was indicated as the organizer of that discussion?
It's Advocate Nontsasa Memela.
And what does it say at the bottom of that block?
This meeting has not been accepted.
Do you have a comment on Mr. Makaleng's evidence on affidavit that he did not attend the meeting and the proof that he provides for that?
I have the comment, Chair, and I still stand by my statement. I did say that he did attend the meeting, and I did not refer to the acceptance because I know that he had first rejected the meeting, and then he popped up before the meeting. I think it was 10 minutes before the meeting. We went to the meeting, we attended it, and we discussed everything in that meeting with them, him and Stan Foslow. Like I said on Friday, that in fact, just to go back, Chair, so that I finish early, I see that he says he was attending the delay meeting.
Another meeting, yeah.
Yes, that was starting from 9 o'clock to 10:30. So I remember that he came in just 10 minutes before the meeting started at 11. Meaning, like, I mean, he was early enough to attend that meeting. So he came, he rejected it, but he was there, you know, and I said Friday, Chair, I understand my former colleagues maybe trying to distance themselves from this because there has been so much that was said about this transaction. And of course, him saying that, okay, he was against the transaction, of course he was. He did say that he wanted to have 7 GPUs sold, but the acting CEO, not Nontsasa, changed his submission to 12. You understand? So, and as the owner of the department that owns the GPUs, I mean, it should not end at being in favor or not agreeing to the sale of GPUs. We are all HODs. We were all HODs. I mean, my understanding is that at an executive level, you have a fiduciary duty to act in the best interest of the company. So at least if we had that kind of an evidence that says, you see, actually, after I have shown my unhappiness about this sale, that the board had already approved, this is what I did. I reported to the relevant authority. Chair, we work for the state-owned companies, and there are certain procedures that have to be followed, like for a person who's not happy about a certain transaction such as this one, to show that, you know what, they did this thing without me and I was not happy and I showed it. Here is proof.
So you are saying 2 or 3 things.
Yes, Chair.
One is you say what he says in his affidavit that he did not attend that meeting is not true.
It's not true,
You
Chair.
stand by your evidence
I
that
stand
he
by my
did come.
evidence, yes.
You even remember that he arrived about 10 minutes before the meeting could start.
Yes, Chair.
And you accept that he had declined, is that right?
I accept that he had rejected
He had rejected the
meeting
invitation.
request, yes.
Yes.
Which is, I do think he thought he will take longer in the delay meeting.
Yes.
The delay meeting, Chair, is not for instance, an executive meeting. Remember, like this one involved the asset that were under his department. So the delay meeting, he could have sent his senior
Somebody
manager and
else,
stuff.
yeah.
Yeah. So when he attended there and decided to come and join us, I thought, okay, he thought, his what presence would be important, and he was there. Yes.
Okay, now that he declined, is that something you came to know afterwards, or is that something you knew before he arrived 10 minutes before that he had declined the request?
I think I knew because at first he accepted it, and during the disciplinary hearing, Chair, and the CCMA, I had this evidence.
Yes.
Just that when I was sending it to the commission,
Yes.
I couldn't find it, but
Yes.
I can still look for it and send it.
Yes.
He had accepted first,
Yes.
and then later on rejected.
Rejected.
Then as
And then
colleagues,
came.
exactly, as colleagues, and then came. And then as colleagues, I picked up the phone and I said, "Oh, child, why are you rejecting? You accepted first." And he said, "I don't know what I don't remember what he said, but what I know is that he joined us
Yes,
for that meeting."
yes. And you agree with him that he was against the transaction, but you say he was there at the meeting.
I agree with him that he was against the sale of the 12 GPUs. Yes,
the number.
he was proposing, like, and he even did the submission that like 7 should be
Yes,
sold.
okay.
And then showed that to Mr. Asimalola Piri, who was an acting CEO.
Yes.
Acting CEO showed him apparently the copy of that Swissport SAA contract that, look, my hands are tied as the acting CEO. This thing says like we should sell all 12 of them.
Okay.
Yes.
Okay, thank you.
Ms. Memela, are you aware that the award of the arbitrator of your CCMA proceedings does not refer to this aspect of your evidence, that he first accepted and then rejected it?
Okay, I did not quote my award. When I was responding, I was not quoting the award from the CCMA.
No, indeed. So I'm
Yes.
asking you, are you
I'm
aware that the
giving-
arbitrator did not reflect that in his award?
Is it saying something opposite to what I'm saying?
The arbitrator's award resolved this issue on the basis that Mr. Makaleng's rejection of attending the meeting had not been made available in the course of the CCMA proceedings.
Yes, and the fact that, Chair, Open Water did not could not prove that indeed he changed his mind and attended the meeting. So it was like his word against mine.
But I must just, I think if you say what you have just said is part of what you testified about at the CCMA, you can say, that's what I said at the CCMA.
Yes, Chair.
If the award doesn't reflect that, it might not reflect it, but certainly if anybody goes to check the recordings, they will find that I said it, if that is your evidence.
That is my evidence, Chair.
Okay.
Let's move to Mr. Vosloo. Is he also giving false evidence before this commission when he says that he didn't attend the meeting?
Okay, can we go to his affidavit? And
Yes,
then-
I'm just asking
Yeah.
for whether you maintain your version that he did not attend the meeting.
I maintain my evidence, Chair, because as I said, the only person who did not attend, who I know for sure that he was not there, was Leon Roberts, being the senior manager of inventory and logistics. Yes.
And Ms. Memela, you've emphasized Mr. Makaleng's responsibility as the owner of these assets. Is that correct?
That is correct.
So did he lead the discussions at that meeting to arrive at a sale price?
Chair, it was not about who is leading the discussions, who's chairing the meeting, because remember, I'm the one who actually called the meeting.
Yes, hang on.
Yes.
You see, you were doing very well. I think when I asked you questions, I put you back to, you can
Yes.
say, yes, he led the discussion, or no, he didn't
No, he
lead
did
the
not
discussion.
lead the discussion,
Yes,
Chair.
and then you'll wait for
Was
the
it
next
you who
question.
led them?
I did not lead the discussions because, we led the representative of JM to put their story on the table based on the proposal. No, I did not lead.
So who led?
Okay.
You might
Maybe-
not be able to say who led because everybody was talking, I don't know, but
Exactly.
just give the best answer that you can give. If
Yes.
it's clear that somebody was leading discussion,
Yeah.
you can say so-and-so was leading. If you are not sure who was leading because everybody was talking. you
Okay,
can-
Chair. Maybe the problem now is that maybe the question how it is formulated in terms of leading the meeting.
Yeah,
Of course, because I called the meeting.
Maybe what you can do is, you can say who chaired the meeting, and then you can say whether there was somebody who introduced the subject
Yeah.
to the meeting, and tell us who those are. And in terms of discussion, whether you are able to say there was somebody who was leading the discussion.
Okay.
If you are able to say, you say so-and-so was leading as far as I'm concerned.
Okay.
If you are not able, you say, I can't say who was leading.
Okay. Because I called the meeting, Chair, then I think I may have been the one who opened the meeting discussions. I'm not running away from leading because I've mostly chaired meetings and lead, but this one I'm saying opening discussions, and I was the most, I think, active in asking questions because I even asked the one that how did they reach the amount that they made the proposal to the acting CEO in April. That's when then they responded via email saying thank you for the meeting and then responded.
Let's then go to Mr. Vosloo's affidavit, if we may. You'll find that in the same bundle, DD25B, at page 742.
Is it not the one that was just handed
Yeah, it
out
is the
now?
one that has just been handed up.
Now, I'm going to ask us to look at Mr. Stanton Leonard Vosloo. For the record, that's Vosloo. If we go over the page to page 743, you'll see at paragraph 6, he deals with this meeting. He says there, I had been interviewed during the forensic investigations into this matter. I'm also aware through these investigations and through interviews with the investigators at the State Capture Commission that Advocate Nontsasa Memela, then HOD Procurement at SART, alleged that I attended a meeting on 2 June 2016 at SART. Chair, that is where the error has been identified. The supplementary affidavit at page 750 makes it clear that he meant to refer to the meeting we're talking about, which is the 21 June
21,
meeting.
okay.
Indeed. But just for reference purposes, that correction appears in Exhibit DD25B at page 750. He says, he goes on, and I quote from his affidavit, the meeting was apparently for discussions on the sale of the GPUs. Reference to the meeting is attached as per Annexure SV1. The meeting was allegedly with members of JM Aviation. At paragraph 7, he says, I deny that I was ever involved with or in any meeting whatsoever where the sale of the GPUs were discussed, any pricing was discussed, or any agreed price was reached. Ms. Memela, if I just stop there, is his evidence before the Commission false?
The part, Chair, that he did not attend the meeting is false. The part where he said the price was not what the final price was not reached in terms of negotiations is correct, because that's when we had asked them to go home and then give us a background of how did they reach the amount that they had proposed to the acting CEO at that time.
And then at paragraph 8, he says, my only involvement was where I received an email from Mr. Jules Ayres indicating the offer to purchase and price offered. I then forwarded this email on 11 July 2016 to Advocate Memela, asking if this was correct and that my department need to issue the invoice. A copy of this email trail is attached as Annexure SV2. Advocate Memela's response was, and then there's another correction here. He indicates that the response was, yes, Stan, this was the price we agreed on. This was on this email that I proceeded to draft an invoice, but he's corrected that again at page 750, because what Ms. Memela's email reflects was, yes, Stan, that was the reviewed price. But let us go to the actual emails so that we can follow it. And you will pick that up at page 747 in the same bundle, DD25B. Ms. Memela, you may need to just go back a page to 746 so that we can see the start of the email, the content of which appears at 747. If you go right to the bottom of page 746, can you tell us what email that is?
So 747 will be in the Mr. Human's thing.
No, we're still in the same document that was handed in of Mr. Vosloo. It's an attachment to his email. So if you just go on further in the pack that you have in front of you,
okay.
and you go to page 746. Let's start at the bottom of that page. There's an email there right at the bottom from Kosi Sokulu. Do you see that?
At the below 746 or 747?
Yes, 746 right at the bottom is the start of the email. Do you
Okay.
see that?
I see that.
And who does Ms. Sokulu send the email to?
Ms. Sokulu is sending the message to Advocate Memela.
And who else?
It's just Advocate Memela.
I think also after that it says Jules, does it not?
After that, it's Jules.
Yes. So she sent it to both you and Jules. Who is Jules?
Oh, Jules is the CEO as per the proposal from JM, is the CEO of JM. I don't know, JM Aviation, South Africa or JM International, but...
And what was the date of the email?
It was the 7th No, it was the 21st of June 2016.
That was the day you had the meeting, is that right?
That's the day of the meeting,
And what time was it sent?
at 14:39.
Thank you.
Yeah.
If you go over the page to 747, what does Ms. Sokulu say to you in her email?
Dear Advocate Memela, thank you for meeting with us today with regards to the ground power units. We would like to give a brief explanation as to how we reached our offer price of 225,000 per GPU. At present, there are newer generation models under a year old available in the market that can be purchased at very competitive pricing. In addition, the worldwide second-hand market for GPUs is soft currently due to the negative economic environment. In consideration of our discussion, we are able to amend our offer price to 248,000 per GPU. Best regards, Kosi Sokulu.
She sends that email only to you as a representative of SART, is that correct?
She sent it to me, yes.
Yes.
Yeah.
And then you'll see above that, there is another email sent on the 7th of July 2016. Who is that from and to?
7th of July.
Yes.
It was coming from Jules,
That's Mr. Ayres, A-I-R-E-S for the record. He's the
Yes.
JM Aviation
JM Aviation.
representative. And who does he send it to?
He's sending it to Stan.
That's
Vosloo.
Mr. Vosloo, yes.
Mhm.
And who else?
And Vuiswa Mbonani, being the senior manager, SCM.
Thank you. And what does he say in that email?
He says, "Hi, Stan, below is our offer to purchase letter."
And then above that, there's a communication between Mr. Vosloo and yourself. Do you
Yes.
see that?
Yes.
What date was that?
The date is 11 July 2016.
And what does Mr. Vosloo say to you in that email, which is a forward of Mr. Ayres' email below?
He's saying, "Hi, Nontsasa. This is the only information I received on the sale of the GPUs to Swissport. Do you agree to this and that we issue an invoice as per below?"
And then your response, as I have it, is above that.
Eh.
What did you say in response to Mr. Vosloo?
I say, "Yes, Stan, that was the reviewed price."
Yes. Now, if Mr. Vosloo was at this meeting with you, why did you not just say to him, Stan, you were at the meeting. You know what was discussed.
Aman. Chair, that will not cover the fact that he was there or not. Ms. Wolfmeyer wants me, he wants an email that would have said, "Stan, you were in the meeting, that is the price." I can't say that because remember I had said, as much as I don't agree with Mr. Stan saying he did not attend the meeting, I agree with him that the final price was not finalized because we had sent the guys to go and check how did they reach the conclusion. So me saying, "Yes, Stan, that is the reviewed price." And
Was that a reference to
the reviewed
the fact that the price had been reviewed after the meeting?
after the meeting, yes.
So, which anyone who had attended might not
Would
have known.
understand, exactly.
Yeah.
Because remember, during the meeting, Chair, on the proposal that was received from Mr. Malola Piri, the amount was lesser. And then when Kosi Sokulu writes to us, writes to me, the amount is now more by 20,000 after we had questioned that. So Stan says, "Okay, on that, this is the only information I have. Is this the price?" And I said, "Yes, Stan, that was the reviewed price." Because I knew that he understood exactly what the background was. Yes.
Yes,
Because,
like-
if he did not understand the background, Chair, he would have said, "What do you mean, the reviewed price?" Yeah, what was it before? Yes.
So,
Okay.
can I just clarify, your evidence is then in that meeting, the price was not finally agreed, is that right?
That's what I said, Ms. Wolfmeyer,
you.
initially. I said to you, I disagree with Stan Vosloo that he was not part of the meeting. But I agree with him that he was, the price was not finalized because we had asked JM people to go back and check how did they reach the price.
So who finally agreed on the price then, if it didn't take place at that meeting?
Who finally agreed?
Or who
Yes.
determined it?
Yes,
Who
from
determined?
SART's side.
Yeah.
Okay, from such side, Chair, that will be quite, because remember, the question now, I understand it is, who made the final decision on the price. Remember, the only time that you can say I've made...
Or maybe let's start a little earlier.
Okay.
Because your email said, yes, that's the reviewed price.
Yes, Chair.
Who did the reviewing of the price?
Okay, the review, after they had gone back...
Apologies.
Okay,
I think
all
that
right.
might
It
have
might
been
have
me.
been me. Okay, who did the reviewing that you talk about in the email?
Okay, the review was done by JM Aviation after they went and checked, and they came back with the reason why they have
They came back
put
with the
that
revised
proposal.
price.
Yes, and then they came back with the revised price.
Offer, okay.
Yes.
Okay, all right.
Remember, the offer was made to, in April, to the acting CEO, Mr. Malola Piri, who said to them, no, don't worry, I'm still going to go to the board.
Yeah.
I'm still going to go to the EXCO and stuff, and then I will get back to you once
Yes.
I get the approval.
No, that's fine. I think Ms. Hofmeyer then wants to find out who at SATA responded and said the revised offer from JM is fine. Who made that decision, if you do
Or
know?
responding to...
Yeah, to this revised offer from JM.
No, there was no email that was made back to JM saying, okay, we agree, or maybe we just continued with the transaction.
Yes, but I'm interested in knowing who in SART then agreed to the 248,000 per unit sale price.
The one with the extra 20,000.
Yes.
The one referred to in Ms. Sakulu's email of 21 June.
I would say, Chair, because, I mean, that's what they came back with after the negotiation, and then we continued, and then it was sent to Stan Foslo, who is responsible for drawing out the invoice. And then he used what was revised by JM, and then he asked me to confirm if this was the revised price. So, like, I mean, to say who made that final decision would be to say, okay, I said, okay, based on this, this was the final decision. Remember, Chair, my duty as the HOD SCM is to run tenders and ensure that tenders adheres to the processes. And this one, it did not go on a tender because the board had already made the
Yes,
decision.
no, I understand that.
Yeah.
You see, I think what Ms. Hofmeyer wants is you have a situation where at the meeting of 21
Yes.
June,
Yes, Chair.
at that meeting you have told me the price was not finalized.
Yes, Chair.
You have told me that JM was asked to go back and look at the price, and then they came back
Yes, Chair.
and they made an increased offer. Okay. Now, at some stage, somebody from SAT had to say, this revised offer is acceptable. And Ms. Hofmeyer's question is, do you know who that is?
I think, Chair, it would now be based on the invoice that was signed by the acting CEO and myself co-signing as a witness. But all I'm saying is that, because remember, the line of questioning by Ms. Hofmeyer was referring to the amount from the asset register that was included in the submission by Mr. Asin Malola Piri. And then now I also want to bring your attention to the fact that he actually signed the revised and final amount, as much as he made that submission to the board. Because remember, that's why the reason why I said let's go back to the minutes, because I know that during the discussion with the JM guys, like they actually asked and said, okay, we are aware that the GPUs were used for other
Ms.
things.
Memela. Okay,
Yeah.
okay.
Yeah.
The question is simple. You were instructed to negotiate, is that right?
Yes.
Yes. When you negotiate, you need to know what authority you have, what you can agree to, and what you don't have power to agree to,
Yes.
and what issues you would need to refer to your principals
Yeah.
before you can agree to. Now, did you have the authority to accept that revised offer on behalf of SAT yourself?
I did not have the
You did
authority
not
to
have.
accept that.
Did you accept it?
I did not write an email to say we
Yes.
accept the price. I think because now there is no evidence that shows that I had spoken to
Yeah.
the acting CEO and
Yeah.
gave him a feedback that,
Yes.
okay, here is the amount that came back, because the fact that we have now the invoice share that states the amount that was revised and signed by the CEO shows that there was a discussion with the CEO that, okay, here is the amount that they came back with. Therefore,
But did you discuss the revised offer with the acting CEO?
my understanding, Chair, as much as I don't remember, I understand Asin as a person who would not sign anything until he understands or until he knows that, okay, here is the feedback, this is what we did, and then here is the feedback. Yeah.
Do you know whether the acting CEO accepted the revised offer, whether in writing or not in writing? Did he communicate to you that this was an acceptable
There's
price?
no written communication, Chair, except
But
the
verbally?
invoice. Sorry?
Verbally, did he communicate to you that this price was acceptable?
As much as I don't remember, I can't remember. I said things that I can't remember. I cannot say
Yes.
that were there, but I'm basing my assumption to the fact that he signed the
Yeah.
invoice for that amount. It
Yes.
shows that we had a discussion
Yes.
verbally before he signed the invoice.
Okay.
Yes, Chair.
Ms.
And-
Hofmeyer, I know that you might wish to round off the point.
Indeed,
I
yes.
do want to take an adjournment as soon as we can, but maybe
There
you
are
might be
probably
needing
2 points,
Yeah,
if
that's
I may
fine.
just
Yeah,
follow
that's
up.
fine, yeah.
Ms. Memela, you were the only person on the 21st of June at SART who was sent the reviewed price by JM Aviation, correct?
Chair, yes, according to the email, yes, I was the only person who was sent the reviewed price by JM. As much as on April also, the acting CEO and the acting CEO, Mr. Mustalzwane, were the ones who were sent the proposal from JM. I was not part of that email.
Yes, but it's the reviewed price that SART sold the GPUs on, and you were the only person at SART who received the reviewed price, correct?
Correct.
Yes. I understand your testimony a moment ago to the chair to be you didn't have the authority yourself to agree to that reviewed price on behalf of SART. Is that correct?
Yes, I did not have the authority, but when it was signed by the CEO, it means I had a discussion with him.
Right, so your evidence is you didn't have the authority yourself, but you do recall a discussion with the CEO about the review price, and that is why you and he, he issued the invoice and you signed it as a witness. Is that your evidence?
Yes, that's my evidence.
Okay. We can take the break, Chair, and then we'll return if that's suitable.
No, that's fine. As I indicated earlier on, we are going to take an extended lunch because of some commitment that I need to attend to. We are at 12:20. We will resume at 2:20. Something that I could not avoid. We adjourn.
Thank you, Chair.
Would you take the file so that we can discuss further? File. No, I don't need yours. I think if we have the one that I return me. Yeah. I want to bring lunch for us too.
Anyway, we can come back here.
It says ground handling services, so I was a bit confused. Yeah, what that was about. If it was for GPUs or if it was just for ground handling.
Don't forget your.
You think I'm gonna So another thing, so all of the JM was to support. But how? But I don't understand how one company to me, it's suspicious. JM mediation. How do you come up
So I'm giving you
but